unfair on service animals. Just a couple reminders for our last session. Please keep your microphones and cameras off during today's presentation. If you have questions, please put them in the chat box and I'll relay them to our presenter as we go along. Also, at the end of the session, if you need a certificate of completion, please email Stacy and she'll get that out to you. So with that, I will turn it over to Kirsten, and thank you again for attending.
Thanks, Kylie. So to begin with, my name is Kirsten Small. I'm an investigator here with the Department of Labor and Human Rights. Been here just under 9 years, worked with many different types of investigations, housing discrimination obviously being one of those, but also employment discrimination, public service and public accommodation, as well as wage claim issues. I've done a number of these presentations, so you've probably either seen or heard from me before. Some of what we'll go through probably is a little bit of a reiteration, but hopefully we can provide some good information today, just better understanding when it comes to things like reasonable accommodations, reasonable modifications, and service animals. It can be certainly one of the most difficult subjects as far as kind of having a best understanding of it. And of all the situations related to discrimination, I would certainly say that anything related to disabilities, but specifically reasonable accommodations and modifications, those can be the most fact-specific inquiries. They might be the hardest ones to just have kind of plain yes or no answers, black and white answers, and it's just a very murky area to go through. So hopefully we can provide some good information to give you a better understanding of what the laws are that pertain to these issues, and kind of what some best guidance or best facts to kind of go off of to try to wrangle and tackle any of these issues. Hopefully it won't be too boring. I always laugh because they either usually put me in the very early morning or in the late afternoon when everyone's just kind of at that after lunch sleepy time. So hopefully we'll keep you awake and you'll get some good information. Like Kylie said, if you guys have any questions at all throughout the presentation, just type them in the chat and she'll let me know, or we'll certainly go through them at the end. But I try to go through them somewhat, at least as we go along. So we'll kind of cover some of the main things we'll talk about today. We'll obviously go over a little bit about the department itself. I truthfully, before I worked for the department, had no idea what the department really did. I did not have a good understanding of what kind of areas they covered. So we'll talk a little bit about that. We'll talk about what housing discrimination is as a whole and kind of the laws that pertain to housing discrimination. Then we'll get into a deeper dive about those reasonable accommodations and modifications. And obviously a big one of those being service animals. And so we'll try to talk through a lot of different situations and different facts that go into a reasonable accommodation request related to a service or an assistance animal. Then we'll talk about some common issues or common things that we may see, as well as best practices for going forward, some kind of tips on what to keep an eye out for, things to watch for, as well as have a better understanding of our process. So if a complaint is filed, kind of walk through what that looks like, what you can expect from that process. Like I said, hopefully we can make this pretty painless, but as I stated, it is definitely a very cumbersome topic. And so there's a lot to go through when it comes to reasonable accommodations. So the Department of Labor and Human Rights, obviously we kind of have two main different categories, and then a third being kind of one of the expectations we have. So of the three pillars, we have the wage and hour division, we have the human rights division, and then we have the education and awareness. When we're talking about the education and awareness, obviously we're talking about presentations such as this. We go through presentations as far as we present for various other agencies, or when it comes to potentially any sort of like outreach or booth type of thing. And then we also provide brochures to the public, just general awareness to the public about the laws that we cover. For the wage and hour division, it's pretty self-explanatory. Obviously, that piece of what we do is related to wages. It is we evaluate any sort of wage claims. So if an individual believes that they have been unpaid or they haven't been paid properly, maybe deductions have been made improperly, they can file a complaint with our office in order for us to do an investigation into those allegations and determine whether or not additional pay is due to the employee or not, and kind of just walk through that investigative process related to wages. We also handle any of what we call youth employment certificates. So that's the child labor piece of it. We work with the Federal Department of Labor, and basically we ensure that any sort of employer that is hiring in youth, whether that's a 14 or 15-year-old or even under 18, there are certain regulations on the type of work that they can do, the hours that they can work, and so we do have jurisdiction over that piece of it. We also handle labor unions, employment agencies, and then independent contractor verifications. So if two individuals believe that they are in an independent contractor relationship, they can complete kind of application or kind of a review of each party would fill it out. We would review those facts to determine if, based on the information they provided us, if we believe that it is indeed an independent contractor relationship or that of an employee and employer. So those are kind of the main pieces when it comes to the wage and hour division. The human rights division, that's going to be the discrimination side of things. So that's related to its discrimination and retaliation. We have discrimination in employment, housing, public service and public accommodations, and credit transactions. When we talk about public service and public accommodations, we're talking about a public service might be, let's say, if you believe that the city water company or the police department are inadequately providing services in some sort of discriminatory manner. So let's say the water department is not billing you properly due to your race. You could file a complaint with our office in order for us to look into it. Public accommodations, it's a little bit different because instead of being a service or a public service that is provided, then it is something that would be like a business type transaction. So if you were to go, for example, into Walmart or into a specific business and you believe you were discriminated against in your interactions within that business, then you could file a public accommodation complaint. And then obviously discrimination in employment, that's the one that we see by far the most in our department as far as claims being filed. And that would be obviously related to feeling that you have been discriminated against in some employment related transactions. So whether that be hiring, firing, being subjected to different terms in employment, anything related to employment that the individual believes is discriminatory would be under that employment category. And then lastly is housing. Of all of the ones, so employment by far we see the most kind of case filings with. Housing would be probably second on that list, followed by the public service and public accommodation. And then credit transactions, that's related to the actual transactions themselves. So if you were to go into a bank and receive a loan, or maybe you were going to a car dealership and you were purchasing a vehicle and using a loan program through them, that would be a credit related transaction. Sometimes some of these areas obviously can bleed over into each other. So for example, if you were having what you believe to be discrimination in lending, so if you believed your mortgage was being improperly handled due to one of those protected categories, potentially it could fall under a housing complaint or a credit transaction complaint. One thing about the Department of Labor that I always at least like to note, especially if you have any sort of dealings with our department, or if you've had either complaints, you're filing a complaint, or you have had a complaint filed against you within or through the department. The department, I guess in my mind, when I first started here, I assumed Department of Labor, huge entity. There's, tons of different employees, maybe multiple offices. That could not be further from the truth. Our entire staff truly could fit into one office if we so chose. We have 5 investigators, and then we have a human rights director, a commissioner, and then we have a kind of a director of operations that oversees our business pieces of the department, and then we have an administrative assistant. So very, very small staff. Like I said, we could easily fit into one office, but realistically, when we have complaints come through our office and individuals either, they feel that they've always been working with the same individual, or they call and maybe request an answer to something, call back and they have the same person. That's why we just have such a small staff, and it's obviously handling all of the different complaints from throughout the state. It certainly can be a limitation on time to get through each complaint just because of that limitation on individuals we have working. So now let's kind of dive into a little bit about what results in these reasonable accommodation, reasonable modification type requests. So to start with that, we have to look at what is housing discrimination. Discrimination is one of those words, kind of like harassment, that there's a legal definition of it, and then there's just a dictionary definition. And even just interpretation-wise, a lot of individuals may have certain interpretations on what discrimination is. Ultimately, what the legal definition is that treating someone differently in the sale or rental of housing because of a person's membership in a protected category. And we'll walk through a little bit about what those protected categories are. But really, what the housing discrimination, when we're talking about it, this is the specific definition that we are looking at. We're looking at whether or not an individual is being treated differently in some sort of housing related transaction because of their protected class, because of their race, because of their religion, any of those protected classes. A lot of times, obviously, when it comes to discrimination, yes, of course, it can certainly be ill-intentioned, but sometimes even people who don't mean to necessarily discriminate can be technically responsible for discrimination if they are found to be treating people differently or interacting with people differently because of those membership in a protected category. We'll talk a little bit more about that. So obviously, with that being the definition of what housing discrimination is, that would mean that the fair housing laws themselves are obviously put in place to prevent that kind of differential treatment. So what fair housing laws do, they make it unlawful to treat someone differently in that sale or rental of housing because of that person's membership in a protected category. The way that the definition of housing discrimination, as well as these fair housing laws, it kind of states that treating somebody differently in that sale or rental of housing, it doesn't just mean that upfront transaction. So it doesn't just mean that, oh, I denied you rental, that means that that's what falls under that discrimination. It's any kind of dealing within that transaction. So it could be the application or denial of that application. It could be the tenants already living there and they're being treated differently based on their protected class because of in any way. So whether it be what their rent amount is, maybe if they feel that they were issued a non-renewal or an eviction because of it, it could be that they had requested a reasonable accommodation and they believe that was denied. Anytime an individual is being treated differently throughout that transaction, not just within that first initial interaction. So the main fair housing laws themselves, there's two fair housing laws that our department would be looking at whenever we have any sort of complaint of discrimination. One would be that Fair Housing Act of 1968. A lot of times you'll see this on maybe paperwork or documentation or that little kind of equal housing opportunity logo. A lot of times it might be classified as a FHA, and what that means is that Fair Housing Act. That is the federal side of the law. So that is the law that was put initially in place by on the federal side of things, kind of started with limited amount of protected categories and has since expanded. But that's the main piece of the federal law that contains all of the fair housing laws related to discrimination and retaliation in housing. The state side of things, that's going to be the North Dakota Housing Discrimination Act of 1999. When it comes to kind of looking up these laws, obviously the Fair Housing Act is extremely large, kind of broad. It's a lot harder to necessarily find very specific details. But that being said, it is still, it's very defined. It's easy to look through if you're kind of savvy with looking up different law pieces. The North Dakota Housing Discrimination Act is what we call substantially equivalent to the federal law, which means that we have a partnership with HUD, which is the federal side of things, housing and urban development. The partnership we have with HUD makes it so that we can investigate housing discrimination cases for them. They can investigate housing discrimination issues for us. And with that partnership, we have laws that are very comparable. They're not so substantially, they're not so drastically different that they can't be kind of evaluated and classified under the same investigation. And so the North Dakota Housing Discrimination Act, that's going to have laws that are coinciding exactly with the federal laws, but in my opinion, they're a little easier to kind of look up and go through just because it's kind of a smaller document. It's a little easier to look up, and those are all available on our website. That being said, they still are, a legal document. There are laws themselves, so they can get a little wordy or a little hard or confusing to understand. So we'll kind of walk through those today, hopefully make it a little bit easier, especially related to those reasonable accommodations or modifications. So we've talked a lot about the housing discrimination, treating people differently because of their membership in a protected category. What is exactly a protected category? So there's a variety of different protected categories. The ones that would be on the federal and state level, because they're kind of a bare minimum that are the protected categories for the federal level, but each state can have additional protections, and a lot of states do, including our own, where it's, even though it's not required under the federal piece of it to evaluate those or to have those protected categories, we kind of have additional protections that are not covered on that federal side. So the federal and state related protections, it's race, color, religion, national origin, sex, familial status, and disability. And familial status would be that presence of children under the age of 18, being pregnant, or securing custody of a minor, basically that related to having a family or not kind of situation that they're being treated differently because of that. The additional protections that we have on the state side of things is the receipt of public assistance, marital status, age, certain victims of domestic violence. To walk through each one of those, the receipt of public assistance, that would be related to if an individual receives some form of public assistance that they believe that they're being discriminated against. A lot of times this would be something like rental assistance, Section 8 vouchers, North Dakota rent help. That receipt of public assistance is a protected category on the state level. Marital status, obviously, that's pretty self-explanatory. Divorced, single, married, being discriminated against because of their position in whatever marital status they are in. They can file on the state level with that. Age would be age 40 and over. So it's for a certain age category and up, not for just any age if you believe you've been discriminated against based on any age. The certain victims of domestic violence, got out of hand here. The certain victims of domestic violence, that's going to be related to a very limited piece of individuals that have some sort of connection to domestic violence. They have to be participants of a state provided program related to domestic violence. So it's not just any individual that is either, kind of going through a domestic violence situation or has gone through a domestic violence situation. It is a very limitedly defined in the law. So it's for only specific individuals in specific situations that are that are related to domestic violence. That is probably of all the protected categories, that's by far the newest. That one, we just, I think it was 2015 session that one officially went through. And so that one's a relatively new category. And again, it just has a very limited definition. So if you believe that either yourself or any individual that you're representing or working with has maybe falling under that category or has had some situation that might pertain to that category, just look up the law really quick because it defines exactly the specific situations in which an individual would fall under that. So going through all of those definitions of what housing discrimination is, kind of the laws that we follow, as well as what those protected categories are, this is just a little brief breakdown of what the kind of complaints that we see coming through our department are. And so I just pulled these from the last biennium. And so this is the 2019 through 2021 biennium. We had 48 total housing cases that were filed. And of those, these are the closure resolutions. So there's a couple different ways that a complaint would be closed, and I'll kind of go through those when we talk about the investigation. But one of the things, whenever any sort of housing discrimination case is filed with our department, we always offer what we call conciliation, or trying to resolve the issues between the parties prior to the completion of an investigation. Conciliation, it can be a variety of things. It can be monetary terms, non-monetary terms, training, just maybe letters of apologies, allowing to be released from a lease. Could be a variety of different situations, but it's basically just resolutions between the parties that are agreed upon. And once they agree upon it and execute those terms, then the case is closed and we consider that it had been successfully conciliated. So of those 48 cases we had filed, 27 of those were closed through conciliation. One of the main things is obviously for both parties it can be a very time constraint filled process. It can be a lengthy process as far as you have to provide a lot of your time to doing interviews, being available, but the process itself can be ongoing for a long period of time potentially. And if it does go forward to a determination, then what would happen is the department, based on the facts and evidence, we determine if a violation of the law occurred or not. So conciliation is always a way for the parties, instead of having the ultimate say by the department, it's a way for them to also have a say. So that's why a lot of times the cases would have kind of a higher rate of potentially resolving through conciliation. Of those 48 cases, we had 13 of them closed as what we call no reasonable cause, or based on the facts and evidence after the investigation, we determined that there was no violation of the law. That is going to, there were zero reasonable cause, which means that we didn't believe any violation of the law occurred. That can kind of seem like a skewed statistic. It's not that we find that a violation of the law has occurred frequently, but oftentimes if it kind of ebbs and flows, it really is so case specific, so fact specific. So sometimes we can have bienniums that we have no reasonable cause, and we have other bienniums that have a number of them, or several reasonable cause cases. So just because there's zero on this one, I just want to make sure it's not seen as oh, we never ever find violations. Of course, they certainly can maybe have resolved through conciliation first, but when we have those reasonable cause determinations, it's true. In my experience, it's kind of seemed to ebb and flow, where we'll have a pile of them in 1 year and then none for maybe another year or so. So it just kind of depends. We did have one that was dismissed. It could be dismissed for various reasons, whether it be that we either didn't have jurisdiction or we were unable to maintain contact with the complainant, or various other reasons. Referred to HUD would be because we had that partnership with HUD where they can investigate cases for us and we can investigate cases for them. Sometimes we'll have cases that are sent to HUD for investigation as opposed to having them investigated through our department, sometimes for a variety of reasons. Sometimes, let's say if it was an accessibility type issue of building design limitations or how, whether it be the architecture design elements of a building and there's concerns with that, there are certain individuals at HUD that are more specialized in something like that. So we may have cases that are referred to them for that investigation. And then of those cases, 5 of them were withdrawn with resolution. A lot of times those would be like conciliation, but instead of having a formal agreement through our department, the parties just kind of decided to agree to terms on their own on the side. And then the complainant is the one that chose to withdraw the complaint, stating, yep, we came to a resolution, we can go ahead and close the complaint. And then 2 of those were withdrawn without resolution. So maybe they just didn't want to proceed forward with the investigation, chose to continue forward kind of on their own without resolving the issues. That could certainly be the case. So of those 48 cases, we did have kind of the breakdown of what they were all filed on. If you look at these numbers, it seems a little odd because there's obviously more than 48 cases on here, but that's because oftentimes cases may be filed on multiple bases. So it could be that they filed on disability and retaliation, or maybe race, color, and national origin. So there could be multiple categories that the individual has filed on. So that's why there's more than what actual cases were filed. So when you look at these numbers, obviously it's very apparent that disability is the most highly filed on item that we have within the department. Reason for that, it's a lot of what we see with these is those reasonable accommodation cases. So of those 28 disability cases that we had, 24 of those had some sort of accommodation issue tied to them. So obviously, when it comes to reasonable accommodations or reasonable accommodation denials, a lot of the cases that we see come through our department are related to those items. 10 of those were retaliation, and then as we go down the line, really it just kind of smaller numbers all the way down. Race, we did have 8 filed on, 6 on sex, but the rest of them were just usually about a couple here and there. When I talk about those reasonable accommodations, like I said, thinking back to this is kind of, to me, a reason why reasonable accommodations need to be looked at so closely and really should be a flag for you in the back of your mind anytime you have a reasonable accommodation request happening, because it is the most filed on by far item that we have come through our department. So it's not that it's always done improperly, but it certainly is something that if either that interaction doesn't seem like it is kind of that back and forth, or if the party feels that they have been denied wrongfully, they certainly may file with our department. For the most part, when it comes to these issues, like I said, it will fluctuate here and there of having a little bit more each biennium versus less. But as a whole, disability and retaliation are our 2 most filed on items, whether that be for discrimination in housing or in employment. It's just the thing we see probably the most, but substantially more so in housing. You see that huge disparity between the other protected classes and disability and or retaliation. So if disability is the most filed on housing issue, what does that exactly mean? Again, going back to that kind of legal definition versus a dictionary definition, disability can mean so many things to so many different people. It can be kind of that large abyss of not knowing what qualifies as being a person with a disability. When we talk about what being a person with a disability is from the department side of things, we can only look at disability under the laws themselves. So under that Fair Housing Act and the North Dakota Housing Discrimination Act. Those are the only 2 laws that we're looking at when we decide if that person is a person with a disability or not. So the definition, the legal definition, is the individual must meet the definition under the law, who's an individual who A, has a physical or mental impairment that substantially limits a major life activity, or B, has a record or history of such impairment, or C, is regarded as being such an individual with those limitations. When we talk about whether or not an individual is a person with a disability, it's not just as easy as saying, well, was it visually apparent that they had a disability? There are so many definitions or disabilities that can fall under this definition that are not easily apparent. They're not things that you may even have any sort of awareness on, even if you know the person well, or even if you've seen the person do things. When we talk about what that physical or mental impairment that substantially limits a major life activity, we're looking at, does the impairment substantially limit them in the fact that those activities that are of central importance to daily life, seeing, hearing, walking, breathing, caring for oneself, learning, speaking, really there's a broad range that falls under that major life activity. So we're looking at any of those type of items. Same with that record or history of such an impairment. And then the last one would be is, even though the individual doesn't have one of those impairments, so they don't have something that substantially limits them in a major life activity, but they are being treated as such. They're being perceived of having such an impairment. So an example of that would be, let's say maybe the individual's entire family or their parents have some sort of mental illness, maybe like schizophrenia or some sort of mental illness. And the landlord believes that it's, maybe it runs in the family, or they believe that the erratic behavior of the tenant, that they must also have schizophrenia. That could be, even though the individual may not have that actual impairment, the landlord or the respondent is treating them as having it. So those are what kind of that regarded as piece of it. When we talk about going through this, it is such a fact-specific inquiry on the specific limitations of that person. A lot of times when it comes to a disability-related issue for like a housing situation, a lot of times it's not exactly disputed, because especially if there was a request for an accommodation, a lot of times there's already kind of been this back and forth. So there's some sort of awareness or knowledge of the person's disability or their limitations. And so it's really, it can be, I guess, a more simplified evaluation of this, of, yeah, they don't dispute that that they do have this impairment, because sometimes there is no dispute. There's no question as to what they believed the individual to be disabled with, or anything of the sort. So this definition itself, this is the legal definition that our department is looking at, and really dependent on the situation, that evaluation of whether or not they're a person with a disability can be extremely lengthy, or it can be somewhat short and sweet when there really is no question or no concern on either behalf that, yes, this person is clearly a person with a disability. So it can only be discrimination if the person who's requesting the accommodation or the modification or the adjustment has a disability, right? Not necessarily. It can be obviously the treatment of that individual, but just because the person, for example, the person who is maybe filing the complaint, you receive the complaint and you go, well, this person absolutely is not disabled. I'm not aware of any disability they have. They can file as what we call being a person associated with a person with a disability. So let's say the individual, maybe they're the person that they live with has a disability, or maybe somebody who is visiting that had requested some sort of modification to like a practice or a policy. Hey, this person's coming by, can they park into whatever spot due to their disability? Those might be reasonable accommodations that aren't necessarily the person themselves having the disability, but it could certainly be somebody who either lives in the apartment with them, or has some sort of association. Additionally, it could be something like in what we call a testing case, or a case where if they believe that there was discriminatory related verbiage and maybe an ad or any sort of like a social media post or something, they can always file on that basis, even though they may not occupy that basis. So just because the individual themselves maybe the person who had filed, you go, well, how can they even do that? They don't have a disability. There are pieces or portions of it that even though they may not have the disability themselves, they may have the right to file. So now we'll kind of get into the main piece of reasonable accommodations, reasonable modifications, and what those mean specifically related to service animals. So we'll kind of walk through each piece of it first, and then we'll get into the little bit deeper dive into what everybody's always so excited to talk about, which is service animals and assistance animals. So when we talk about reasonable accommodations, all that is a change or exception or adjustment to a rule, policy, practice, or service that is there to eliminate some sort of barrier for an individual with a disability. So if the individual's disability is resulting in them not having the same kind of enjoyment of the property because of their disability, they may request these modifications or changes to allow them to have the same kind of equal enjoyments and benefits of the property as an individual without a disability. So that's kind of what the general definition of a reasonable accommodation is. Fair housing laws, whether it's the state side of things or the federal side of things, they do require reasonable accommodations to be evaluated, to be looked at for individuals with a disability. There's basically provisions under each law that require a landlord or a respondent to evaluate any sort of reasonable accommodation request that is there for an individual with a disability. If you fail to either participate in that process or improperly participate in that process, then failure to do that reasonable accommodation could constitute a discrimination based on disability. Couple main things to kind of keep in the back of your head as we go through these, and I'll probably say it more than once because it is something that comes up frequently. When it comes to reasonable accommodation cases, they are going to be determined on a case-by-case basis. There's not going to be a one-size-fits-all. There's not going to be one request that's exactly the equivalent or the same as another request. It's going to really have to be looked at on an individualized basis. You have to look at each individual reasonable accommodation request and determine whether or not it can or cannot be provided and kind of the reasoning behind that. The reasonable accommodation requests in general, they do not have to be in writing on a prescribed form. They don't have to use specific magic words. They do have to illustrate that they are indeed requesting some kind of change or alteration or exception related to a disability, but it doesn't have to be magic words. It doesn't have to say, I am requesting a reasonable accommodation. It does not have to say, I am a person with a disability under the law, and these are the things I'm requesting of you to eliminate that barrier. Really, reasonable accommodation requests, for the most part, they have to be in plain language as far as understanding that they are indeed asking for some sort of change or exception or adjustment, and at least some sort of reasoning or tie to that being needed due to some kind of disability for the most part. Again, very, very case by case. And if you are going to say, well, I didn't know they were asking for a reasonable accommodation, it kind of look at it from a very broad sense of, would any average person looking at this have no idea that this was being requested as a reasonable accommodation? If the answer is, well, I don't know, I think somebody might see it as such, then probably handle it like a reasonable accommodation request. As we talked about, these are the most commonly filed on issue in our department and with HUD as a whole. It's something that we see very frequently, as if individuals are landlords or working in the housing field, they can attest that these are issues that are very frequently brought up or presented in any sort of housing situation. It's very, very common. The requests themselves, obviously, they can be made by individuals who are currently residing at the property, but they could also be prospective applicants or residents. When that reasonable accommodation process, again, all it is some kind of alteration or change to reduce or eliminate a barrier due to a disability. So if, let's say, in the application process, they're requesting an accommodation maybe to better handle the application, whether that be help filling it out or some sort of modification to what the application process is. They could be requesting things like an assistance animal or a service animal as part of their application. And you can receive reasonable accommodation requests at any point throughout the process. And so those are things that you'll have to be aware of, because it's not just, your obligation does not just stop only with current tenants. It has to also extend to potentially individuals who are not necessarily active tenants. They could be one's prospective tenants or applicants. They could even be potentially, if there's some sort of change, let's say the individual is moving out and they're requesting to a change or alteration to whatever that common practice is, that could be a reasonable accommodation request as well. Respondents need to address these requests in a timely manner. There is not a set defined time frame. There is not they have to respond to those requests in 10 days. They don't have to respond to a request in 20 days. There is not a black and white time frame that a respondent has to address these kinds of requests. But when we say that they need to be addressed in a timely manner, again, this is going to be something that's looked at on a case-by-case basis, but you can't just let these accommodation requests kind of hang out, hoping they'll either go away, because the untimely processing of it in and of itself could result in being considered a denial. So if the respondent receives the request, they go, well, I gave it to Susie, but she didn't, want to work on it. So then we gave it to somebody else. If there is an untimely delay in those requests, that in and of itself could be a denial. So when you get those requests, it's very important to understand that a request is being made and what to do next with those to make sure that they are being responded to in a timely manner. The requests themselves, again, they may impact the person's individual residence, but it can also potentially impact common areas as well. So it's any time that, again, the individuals requesting some sort of modification to be able to have those equal opportunity to use and enjoy the dwelling. That could be, again, in those common areas. It could even just be in the hallways. If they're asking, for an assistance animal or service animal, they may be walking through the general hallways, which in turn would impact those general common areas. It could be if there's, for example, like a community room, things like that, it could impact those areas. So even though it's involving that individual, the entire building and the parking lot, garages, anything of the sort, obviously could be impacted by any reasonable accommodation request. A little different than reasonable accommodations is reasonable modifications. It's kind of easy when you just think terminology-wise. Accommodations is you're accommodating some sort of request. A modification is you're modifying some sort of request. It's rolling off the edge of the tongue. Certainly modifications and accommodations can be a bit of a tongue twister once in a while, but we'll talk a little bit about what the modification side of things. These are structural changes that are made to a unit or the common areas for individuals with disabilities. They are a little different because a lot of times those accommodations are just those alterations to the practices, the policies, kind of the active behavior or policy pieces of it, whereas these are more related to the actual physical alterations of the property. So this might be widening doorways, it might be making a ramp, installing grab bars, lowering cabinet heights or like countertop heights in a kitchen or in some area. Those might be all related to modifications. When we look at those modifications, the same undue hardship, and we'll talk a little more about that undue hardship, that same undue hardship test will apply. So if the modification cannot be made, a lot of times the respondent would have to demonstrate that there was some sort of undue hardship that results in them not being able to provide that modification. When modifications are made, it's kind of important to note that when the individual does leave the property, generally speaking, they do have to return the interior pieces to the original condition, but any exterior pieces, for the most part, do not have to be returned necessarily to their original condition. There's a lot more guidance on that related to those modifications on HUD's website. They have, we'll talk about that later on, of some great guidance things or helpful tools for you guys, but HUD does have a lot of good guidance on different reasonable accommodations and modifications, just kind of fact sheets, and a lot of that alterations on what needs to be returned is applied in those fact sheets. So for modifications, one of the biggest differences is generally a complainant would be the one to pay for these modifications. So if they make a request to have some sort of modification, generally speaking, they are the ones that would be paying for those modifications. So if it's grab bars, they would be the ones that would be purchasing those and installing them. It's that the respondent would be allowing those to be installed as a modification. There are some limitations to that as far as if the building itself qualifies under what we call Section 504, which really means that whether it's the building or the organization or the group itself that kind of manages that facility, if they receive some sort of federal financial assistance or kind of it can be a state or political subdivision, institutions, organizations, and other entity that receives any kind of federal financial assistance. And it's not just related to HUD. It's not just housing assistance. It can be that they're receiving some sort of financial backing from any sort of federal program or federal grants, things like that. They may fall under that Section 504. If they fall under those, the modifications have to be paid for by the respondent. It's not that the complainant is the one that has to pay for it. So in many situations where there's no federal funds being kind of changing hands, then the tenant would pay for those. If it's something where the building or the respondent receives those federal funds, then the respondent pays for those. So that's the big difference between whether or not, reasonable modification, most of those costs, for the most part, there's not usually a lot of costs associated with it, but if there are costs, oftentimes that'll be on the respondent, whereas modifications, in many situations, those modification costs would be on the complainant. They still could certainly file with us, though, if they had requested make some kind of modifications, install grab bars or widen doorways, and the respondent would not permit it. Then again, we'd have to look at those factors on why the respondent denied the request. So big differences between the two. Reasonable accommodation relates to that alteration or change to a rule, policy, practice, or service. Costs are paid for by the landlord. Again, a lot of times accommodations, there's not necessarily going to be a cost per se, but if there is a cost associated with it, the respondent would pay for those. The reasonable modification, that's going to relate to the removal of the physical barriers, whether it be installing things that like I said, grab bars or lowering counter heights, or actually installing things like ramps or other pieces that would remove that physical barrier. Costs are paid for by the tenant in those private situations, but anything, again, with those federally supported programs, that's going to be paid for by the landlord. Again, I told you I was going to reiterate this. I didn't lie. Any of these type of requests, whether it's accommodation or modification, they do not have to be specifically in writing or provide some sort of magic words. As we'll talk a little bit about, it's always helpful to have a clear understanding from both parties, but the requirement to have it filled out on a form in order to even proceed forward with it, that is not required under the law. So when we talk about what is reasonable, there are kind of two main pieces to determining whether or not it is reasonable, and it is very, very much going to be on a case-by-case basis. It's going to be up to the landlord to provide that there's some sort of undue hardship. When we talk about undue hardships, there's kind of two pieces to it. A is that the respondent, that if they were to provide this accommodation, that it would impose some sort of undue financial or administrative burden in order to provide that. So if they were to provide that accommodation or modification, that it would basically be such a financial burden or has some sort of alteration, the administrative process, that administrative additional burden, whether it be paperwork or you'd have to hire another individual in order to handle those type of requests, those may constitute an undue hardship. But when we look at those, they're very, very much on a case-by-case basis. They're going to be looking at, if you're going to say it was financially too expensive to provide that accommodation, you better be prepared to present the information that definitely documents and proves that, based on, let's say, whatever the monetary amount coming in versus what the cost of it was, it's not just going to, we don't just take words for it of does seem like that was a little expensive. We're really going to look at the individual situation and what the financial burden is associated with that in conjunction with the business. The second piece would be that it can obviously prove to be an undue hardship if, by making that accommodation, it would require some sort of fundamental alteration in the nature of the provider's operation, then they may be able to deny that request. If the answer to either one of those is yes, so let's say it does impose some sort of undue financial or administrative burden, or it does alter the business, the nature of the business, then even if those answers are yes, you still may be required to provide other options. You may, whatever the requested accommodation was may not work, but you still have an obligation as a housing provider to be able to provide options for what those potential resolutions could be. When we look at, again, those reasonable things, we're looking at whether or not it imposes those other things. If not, then why was the request denied, or kind of what other options were out there. So it's very much, we call it an interactive process for a reason. It's very much a back and forth between the parties to really determine what a best solution for each of the parties is. So now we get to service animals. This is the part of the presentation I feel like, certainly can be the most interesting, but it also is the one that elicits usually the most amount of questions and usually the most amount of distaste for the department, for the laws themselves. Unfortunately, it is just like I said, cumbersome process. Reasonable accommodation requests have really changed over the years. They've kind of gone back and forth with relation to service animals. Since I have been doing this, they've very much been kind of an open piece on the tenant side of really service animals and assistance animals. They're a broader definition than what most people think, and that's why I think it just has kind of such a bad rap. And so hopefully we'll kind of clear up some of the questions and some of the pieces that we see commonly that people don't necessarily have a full understanding on. So when we talk about service and assistance animals, this is what we consider a reasonable accommodation request. And basically, the individuals who are disabled, they may require the use of that service or assistance animal to eliminate the barriers due to their disability. So this is, generally speaking, a reasonable accommodation request of that tenant requesting an exception to a no pets policy or no pets rule, or an exception to maybe a limited pets policy or a limited pets rule. So whether that be maybe the number of animals, or maybe it's an alteration or request to have for a specific breed or specific size. Maybe there's a size limitation on the pets in the facility. And so this reasonable accommodation request may be requesting to have an exception to those rules. Again, to deny those accommodation requests, the landlord would have to prove that providing such an accommodation is not reasonable, it's not necessary, or causes one of those undue burdens. And so this is when we look at what a service or an assistance animal, think of these not as pets. They are not considered pets. They're assistive aids. So just as you may see, for example, an individual who's in a wheelchair or needs a walker or cane to walk around a facility, this is a similar assistive device. Those animals are providing the tenant some sort of relief that would allow them to fully use and enjoy the benefits of the dwelling. So when we're looking at these, a lot of times people, kind of quick to jump, well, a service animal, they provide a certain task. An assistance animal does not. The law that itself provides for both types of animals. There are some different laws that pertain when it comes to service animals over assistance animals, but for the most part, a lot of those differences in the law pertain to kind of entering in public spaces, not necessarily residing within their own homes. And so a lot of times we hear a lot of complaints or concerns about, well, there's a dramatic difference between a service animal that's providing some sort of task versus an assistance animal. Both are not considered pets, and both can be very much considered assistive devices for the individual's disability. So a lot of times in these situations, the tenant might have a letter or a prescription from some appropriate professional, whether that be a therapist or a physician. And if they meet the definition of being with a person with a disability, they are entitled to request a reasonable accommodation, and that interactive process kind of starts at that point. So if the person's a person with a disability, they begin interacting in that interactive process, requesting that reasonable accommodation. That's kind of where service and assistance animals kind of starts and plays in. There's a lot of guidance from HUD in relation to service animals specifically. I know some of it's a little bit older, some of it's a little bit newer, but all of it is very easy to go through. They the joint statement that's from 2004, that one is it's kind of a good quick guide to look through, and it states that housing providers may not require persons with disabilities to pay extra fees or deposits as a condition of receiving a reasonable accommodation. And so this one really is, it's still, we still view it the same way. It's still evaluated under law the same way, that if there is, let's say, a pet deposit or a pet security deposit that has to be in place for animals, the request for a reasonable accommodation to have a service or an assistance animal, the condition of receiving that reasonable accommodation cannot be dependent on them paying those extra fees or deposits. So basically, it's stating that you can't require an individual to pay some sort of fee or a deposit, a pet deposit, for example, in order to be allowed to have that service animal or assistance animal there. Really, that's, like I said, it's going to kind of be universal, even though it's from 2004, the guidance is, it is still reviewed and evaluated under that same exact perception. It's if the respondent is requiring an individual to pay a pet deposit on an assistance animal, that is not going to be permitted. There's also some additional guidance that HUD provided in 2013 that's just a notice concerning specifically service and assistance animals that is very helpful. The department, we use all of these documents frequently. Like I said, there's a lot of information out there that can be I would say a little hard to go through, a little bit cumbersome, and a little bit difficult to kind of understand. These three documents, the joint statement, the notice concerning the service animals, and then the notice from January of 2020, these are really helpful, kind of question answer, well laid out. They provide a great understanding of what how HUD and the Department of Labor and Human Rights looks at these type of issues. So they can be very helpful in those kind of situations. When we look at the maybe a variety of types of assistance animals, this is something important to note because sometimes it's easy for us to assume, well, a service and assistance animal should always be maybe a dog or maybe a cat. It's not always going to be. There are going to be certain situations and circumstances where they may have perhaps a unique type of animal or maybe even like a reptile or something that, although it may seem off-putting for many of us, there may be a medical reason as to why they have that assistance animal versus others. Obviously, you will talk about this later. Again, I'll reiterate it, but when we have any sort of medical documentation, we are not the medical providers. We're not the ones that are acting as the doctors or should be acting as the doctors of saying what we believe should or should not be an effective assistance animal for an individual. Potentially, let's say if the individual has maybe they're allergic to dogs, so their assistance animal cannot be a dog, which may be a common assistance or service animal. Maybe there is a specific reason why a certain type of animal is used as their assistance animal versus some other type of animal. There might be reasons for it, so it's always important to remember that it could be a wide variety of different types of animals. And so when you're looking at those reasonable accommodation requests, again, those kind of sudden rash, no way, this isn't what we would ever consider as a service animal, you kind of have to look a little bit deeper at those because there may be situations in which you do have to provide those accommodations, even though they're not the norm. So a couple issues that come up frequently when we talk about service animals and assistance animals, when we talk about whether or not they're direct threats. So a lot of times we see, specifically with things like breed restrictions or concerns about the safety of maybe, let's say it's an apartment unit that has a lot of young children there, and so they're worried that having a dog come in, maybe that dog would be um, a risk to the residents. The direct threats, that's going to be something that's very much, again, a case by case basis. We're going to look very closely at whether or not it's just kind of a perceived threat or what the likelihood or reality. Does the animal have maybe a history of concern related to aggression or to biting individuals or kind of attacking other people? Is there just a perceived threat that just the generalized breed, they tend to have a perception that they're more aggressive? Or is there actual evidence or reasoning why this specific animal you have concerns with? And so if an individual or a respondent is stating that they have concerns about direct threat, that is going to be something that has to be looked at very closely because of the fact that it really depends on the specific situation, not just a generalized assessment of that type of breed or maybe even that size of animal that, well, we're worried about how it's going to impact our maybe like our neighborhood or the apartment complex. It's really going to have to demonstrate that there is a valid potential threat. One we see come up commonly as well are city restrictions. We've seen this a lot. I would say about the last 5 years, there's been a lot of repealing of any sort of breed bans within cities, but there are still a number of cities that have breed bans. When it comes to any sort of city restrictions, it's a very kind of gray area where the respondent is still required to follow kind of those fair housing guidelines as far as, what those, was there an actual direct threat or anything of the sort? if they're going to deny a reasonable accommodation, they have to follow those fair housing guidelines on what would allow them to deny that accommodation request. So if it is that undue hardship, or if it is going to cause some sort of direct threat, that's one thing. But if it's just because, well, the city has regulations on it, we don't want to be, at odds with the city or allow things that the city are requesting that are not allowed, the complainant themselves is the individual that basically would be kind of dealing with it on the city side of things, and they can file against cities if they believe that their ordinances are not basically within the realms of what the fair housing laws are, or with any of the discrimination laws. So if they believe that a city ordinance is not providing an exception for individuals with disabilities, or for things like service or assistance animals, they can certainly combat that with the city. It doesn't always play into the landlord or the respondent being the one that can be the one that says no to it because of the outside entity, i.e. the city's restrictions. Common areas. Again, those reasonable accommodation requests certainly can bleed into having situations where the animals may be in common areas. Again, same kind of undue hardship test. If you're going to say that they cannot be allowed in common areas, only in those specific situations that you can either prove, again, that it's some sort of undue hardship, that it's a direct threat, that it's unreasonable in some way. You have to prove that that's the case as to why you couldn't allow it. We've seen situations or cases where individuals with disabilities were restricted from being allowed to use common areas with their assistance animals, and it was found to be a violation because, again, those common areas also are the enjoyment and benefit of the property. So if the individual is not able to enjoy those benefits of the property, they are not getting the same kind of level playing field as any other individual or tenant that does not have a disability. If there are specific requirements of an animal, those could be problematic when it comes to, again, those reasonable accommodations. If there are certain animal addendums them in themselves are not against the law, but certain specific regulations on those could be problematic. So if you're requiring the animal to be spayed or neutered, you're requiring it to be a certain breed or have certain weight limitations, those could be problematic. Again, just kind of same interpretation as requiring them to pay some sort of pet deposit. Having those specific regulations in order to allow a reasonable accommodations, kind of that if you're limiting down the ability to get those accommodations, that in and of itself could be problematic. Whereas if it's more of a case-by-case basis, you're evaluating each of these things and looking at the animal truly as being an assistive device, some of these limitations or these restrictions wouldn't necessarily be applicable. So those are things that if you have an animal addendum, that in and of itself is not necessarily a problem, but make sure that those animal addendums, if they're being used for service animals, are not overburdensome and very limiting. That being said, of all of these things, it kind of sounds like, it's somewhat of a free-for-all. It is not. There are still expectations you can have on the behavior of the animal, the behavior of the owner. So you can have expectations on, making sure that the animal is within control of the owner at all times, that they're cleaning up after the animal. It's the individual still has expectations that they, still have to follow the rules and regulations that are provided in the lease or by the building. But as a whole, some of those restrictions that you provide, those can be problematic, but you can still have expectations for the tenant to ensure that the animals being cared for, that they're, behaving properly, things like that. So what if you have a tenant that has a disability as well, such as allergies, that won't allow for that service animal to be in the unit? So let's say the next door neighbor has severe allergy problem. They have concerns with the service or assistance animal being brought in. What do we do? Well, those are going to be looked at again as that case by case basis. You're going to have to look at each individual's request for an accommodation. So, if the one individual who's requesting to have the accommodation of the animal in their unit, you would assess that reasonable accommodation request. And is it, again, that undue hardship or is it unreasonable? And if so, why? And then you also have to look at the other tenant who, again, may have a severe allergy and look at their reasonable accommodation requests. And you may have to work with each individual kind of separately to determine a best solution for both parties. These are cases or situations where it is absolutely best to get an attorney or have an attorney take a look at these things and make sure that you're getting the best advice from somebody who has a legal background in these situations to make sure they're being handled properly. We did have a change to our law, not this most recent biennium, but the last biennium, the last legislative session, in regards to basically it's the biggest piece here is reliable supporting documentation for any sort of service or assistance animal. What the law itself was kind of moving to change is those questionable documentation pieces, maybe online documentation or paid for documentation, and really trying to limit those situations to ensure that things were being kind of handled properly. The big change with this is one where I kind of surprisingly, I would say, it has not been brought forth to like the Supreme Court or even district court about what that reliable piece means. In law, when they use words like that, a lot of times case law will be kind of what represents what that reliable supporting documentation truly means. But in this case, it really hasn't gone to court in many situations to determine what that is. And since COVID and the changes in what telehealth or online health services are, it is harder and harder to determine what, again, is questionable documentation just because it's provided online. Because you can certainly have a provider that is used specifically only online through telehealth services. That's absolutely a legitimate form of care. It's something that's just kind of in recent years changed. So it's just something to be aware of, that this law exists. It has not been presented up as far as, again, like the Supreme Court or anything on a more legal basis determining what happens with this law, but this is how the law is currently. So as we talked about, can requests be denied? Absolutely. There are situations that a request could be denied. Is it an undue hardship? So again, would it impose that undue financial or administrative burden? Would making that accommodation or modification require some sort of fundamental alteration to the nature of the provider's operations? Does the request pose a direct threat? Again, not a perceived threat, but something that has a little more supporting documentation behind it. Consider the nature and the duration and the severity of the risk of injury, the probability that injury will actually occur, whether there are any other reasonable accommodations that would eliminate that direct threat. So kind of weighing your options of what else could we do to potentially either provide this accommodation request, or are there other ways that we can go about making sure that there is not the direct threat. So can the landlord themselves ask for documentation in a reasonable accommodation request? Yes, they can in some situations. So it really depends on the circumstances that are there. If the individual has either something that's an obvious visual impairment, it's obvious to see what the request is tied to the disability, no. In that situation, they cannot request additional documentation. If they provide documentation that clearly demonstrates the individual, is a person with a disability or meets the definition of being a person with a disability, and whatever the requested accommodation is needed in order to alleviate any sort of barrier due to that disability, that can be enough documentation. That may be enough to demonstrate, yes, this person absolutely needs this accommodation in order for their disability. Then again, the only ways the respondent could deny them is if those circumstances lead to it either being an undue hardship, not reasonable, or poses that direct threat. So there are times where you can ask for additional documentation. There are times where you cannot. It's really going to be dependent on that specific specific situation. So again, if the documentation you receive for the accommodation request is not clear, you can ask for additional documentation that verifies that presence of a disability and or explains the connection between what that requested accommodation is tied to their disability. But remember, you are not the doctor. You're not the medical provider. If their doctor or medical provider does make a clear connection between what that accommodation requested is and the disability, that's it. You cannot ask for more. You can't request or require additional documentation. The only times you can deny those reasonable accommodations, again, is those specific situations that can be clearly demonstrated of undue hardship or that direct threat. Just a short touch base on retaliation, just because it is, again, one of those top filed on items, and we do see it a lot. When it comes to reasonable accommodation requests, it can be kind of a tedious process sometimes. It can be a lot of back and forth between both parties, but it is important to remember that you cannot retaliate against an individual just because they have requested an accommodation or even that they had potentially filed a complaint with our office. It's retaliation. It's kind of a natural human reaction to things. If an individual feels that the allegations are not true, or they believe that they didn't do anything maliciously, they absolutely were trying to go through the situation in a productive, positive manner, and it just didn't work out, they may feel that they're being slighted if, again, that individual files a complaint with our office, or continues to make additional reasonable accommodation requests. They may be inclined to retaliate against the individual, and that is not permitted under the law. So it's very important to make sure anyone who deals with the public, especially when it comes to these reasonable accommodation requests, just as reminders to them frequently to make sure that they're not having any sort of form of retaliation as a result. So what happens if somebody does file? If somebody does file a complaint with our office, it can seem a little bit overwhelming. You're maybe not have dealt with a situation like this. It's any individual who believes that they have been discriminated against, and they can explain that nexus or that connection between whatever the harm is and the discriminatory category, or that protected category, and they are alleging discrimination occurred, they have a right to file. We obviously determine whether or not we have jurisdiction to proceed forward with the complaint dependent on a couple different factors, as long as the respondent's not exempt from some sort of discriminatory or the housing discrimination laws. If there's any allegations that fall outside of the statute of limitations, those are all things we consider when we're looking at jurisdiction. But as long as they are alleging complaints that we do have the ability to file under our law, and they're demonstrating that connection, and they're establishing that jurisdictional piece of it, then we can file a complaint. Once we file the complaint, so we write kind of a summary of what the allegations are. We send that to the complainant. The complainant would then sign that complaint and send it back to us. Once we receive the signed complaint, that's what officially opens the complaint with our department, and then we would begin the investigation. We are always going to be a neutral party in these investigations. We're not on the respondent's behalf, we're not on the complainant's behalf. We're solely just the middleman, just determining if, based on the facts and evidence, a violation of the law occurred or not. During that investigation, we're looking at those facts and evidence. We're doing interviews, we're performing the full investigation into the allegations. As I explained previously, conciliation is something that's offered throughout the process. So either party can present any sort of potential resolution offers. And if they're agreed upon, at that point, the investigation would end. As long as the conciliation agreements are kind of signed off on or agreed to, then we would close our complaint and there would be no further investigation. So conciliations offered throughout the process all the way up until a determination is issued. Then if there's no conciliation that's successful, then once we complete the investigation, we issue what we call a determination. And that's just a final report explaining our conclusion. So it explains whether or not we believe a violation of the law occurred or not, and explains exactly how we came to that conclusion. If we believe that a violation of the law did occur, then we issue what we call a charge, and that basically explains how we believe a violation of the law has occurred. If we do not believe a violation of the law occurred, we still issue out that determination, and then the case would be closed with our department. So kind of things to watch for, how to make sure you're not doing anything wrong when it comes to these situations. Biggest thing, easiest thing, I say that tongue in cheek, easiest thing, because the law itself can be very complicated, but knowing the law, obviously, that's going to be the main way to prevent any sort of violations of the law. But ignorance to the law itself is never going to be a defense. So if you are not sure on what to do in a specific situation, the department, unfortunately, we can't provide any sort of advice or guidance, but visit with an attorney that's knowledgeable in fair housing laws. There are a lot of them out there. There's a lot of attorneys that have worked with many housing cases that have come through our department. They can certainly provide you some guidance on what best practices are to respond to reasonable accommodation requests or modification requests. Train your managers and staff, specifically the ones that are going to be working with the public. If they're, let's say, going to have either tenants coming in or even answering calls, and somebody says, hey, I have an emotional support animal that I'm going to need for this unit, and the person, whomever had answered the phone, said, oh, no, we don't allow pets, you're not able to do that. That could be problematic if they're providing information out to people that isn't necessarily true. There still has to be that reasonable accommodation process, that interactive process that's gone through. So make sure that anyone who's dealing with the public, even if it's just kind of on a whim, make sure that they're aware of either the process to walk through or who to direct that person to, or bring that information to if a reasonable accommodation request comes in. Avoid those sudden and rash decisions. Again, taking time to think through and evaluate the request prior to jumping to the conclusion and stating no. Gathering that information, gathering the documentation. Is it unreasonable? Is it an undue hardship? Make sure that you're evaluating those factors before you had that sudden rash decision to say no. Be consistent, have consistent practices and policies, document everything. In the day and age that it's so easy to document things, make sure you're documenting these kind of requests and the processes. It will be very helpful. Like I said, we have some information on our website. HUD has some great fact sheets and notices that provide a lot of information about service and assistance animals. That's super helpful. Very easy format and everything to work through. So make sure you go through those. Again, biggest things to keep in mind when it comes to these requests. It's not always going to be a clear and concise statement. It's not going to always be easy to identify that they're making a request, but make sure that you're kind of listening for those key facts of, are they requesting some kind of modification or change in order to overcome some sort of limitation or barrier, or ensure that they have the same enjoyments because of their disability. Make sure you're responding promptly. Any of those undue delays might be deemed as a failure to provide an accommodation. Think about, there's a thing called dance when it comes to reasonableness. So the first one being disability. Does the tenant have a disability as defined by the laws? The accommodation, is the tenant requesting some kind of accommodation to the landlord's rules or practices? Is it necessary? So is that accommodation that's being requested necessary for the full use and enjoyment of the property? The cost, does the accommodation or modification impose an undue financial or administrative cost to the landlord? And then lastly, effect, would the accommodation or modification affect a fundamental change in the landlord's business? And so if you walk through each one of those pieces of it, it kind of helps you understand or look a little bit deeper on, is this a reasonable accommodation request? Is this reasonable? Is this some sort of undue burden or undue hardship? It's just a kind of thing to keep in the back of your head, because those are things that we would be looking at very closely. And again, as soon as you determine any sort of reasonable accommodation request is being made, make sure you listen, you take notes, you understand what's being requested, so that it's, easiest to take those next steps in that interactive process. So that's all of it. If you guys have any questions, like I said, it's when it comes to reasonable accommodations specifically, they tend to be the most fact specific and most detail specific situations, where there are no two situations that are going to be the same. Even if they're the same kind of request, they may have different facts, whether it's the individual's diagnosis or whether or not it's reasonable. All of those factors are going to play into it. So it really is very case specific, but I'll hopefully try to best answer any questions you guys have.
Can a landlord require a prospective tenant to have 2 or 3 times the amount of rent as income, or is that a way of discriminating against public assistance?
It certainly could be. So there's not a specific law in our laws. There may, landlord tenant, I know that there's some kind of laws and guidelines regarding security deposits with them. If the individual, when it comes to something like is receipt of public assistance, really what has to be demonstrated is that they are being treated differently or being discriminated against because they receive public assistance. So in a situation like that, it certainly could be something like almost like a disparate impact, where it's impacting individuals who receive public assistance because it's a higher amount, but there really would have to be, I guess, more of a tie where they'd have to really demonstrate that the reason that they were doing this is to eliminate any ability for an individual with receipt of public assistance to be able to apply. And I think it'd be a little difficult to necessarily have that information or kind of that backing, but that's really what we would look at. If they could show that there was some sort of disparate impact because of that, then potentially they could certainly have a case indicating that higher security deposit is discriminatory towards people who receive public assistance.
Just to kind of follow up with that, those of us that help people find housing are running into that a lot, with landlords requesting their income to be 2 or 3 times more than what rent is. And we haven't quite pinpointed if it is discrimination because they are receiving like a housing voucher type deal, or what. So we were all kind of curious.
Yeah, and when those ones, the tough thing is we haven't seen many of those cases or any of those cases necessarily come through our department. And so it's being it's a state-only category, it's not one we really can go to look at how HUD handles it or how they've seen other court cases in the past deal with something like that, because it is a state-only protection. So really, I think until either a complaint is filed, it would really have to be evaluated at that point. And again, it'd be a lot on the facts and how it could be demonstrated that it is limiting them because of their receipt of public assistance.
Okay. And then, is an assistant animal the same as an emotional support animal?
Oftentimes those two would be kind of interchangeable. The emotional support animal, oftentimes an assistance animal, a form of that oftentimes is an emotional support animal. So when they talk about assistance animals, a lot of times emotional support animals fall under that kind of umbrella.
An older 4-story apartment building. There is an elevator, and in case of an emergency, the only way to get out would be the stairs, and this person is confined to a wheelchair. We do not have any units available on ground floor. Do we deny these people, or is there a better solution?
That one's going to be really a case specific one. I can't really provide a yes or no answer just because that's more of like a legal guidance type of question. I guess it's going to depend if they're requesting to have a lower unit as an accommodation, and they're requesting it because of concerns potentially for the likelihood of a fire or an emergency occurring. I guess those would be things that you kind of look at of whether or not the request is needed, and kind of what they are specifically requesting. But I think that one would be best for an attorney type of question, just because it's more of a yes or no type of question.
Excuse me, are there any other questions or comments?
We do have another question that was sent directly to me. Are emotional support animals considered service animals?
No, service animals are, I mean, there could be, I guess, potentially situations where they would be considered pretty closely tied to, but service animals by definition are the animals that are truly specifically trained and provide a specific service. So like a seeing eye dog, or maybe a dog that alerts to seizures or something, some dog that's specifically trained for certain situations, and they're very limited. Service animals are very limited. I think it's dogs, and just I think there's like miniature horses, I think might qualify. They're very specific situations, and they have to be trained for a certain task. So emotional support animals are not the same as service animals, but emotional support animals are often the same as assistance animals. But like I said, for a housing situation, for the most part, regardless of whether it's a service animal or assistance animal, a lot of the same circumstances apply. When you look at that, it's the January 2020 guidance from HUD about service and assistance animals. That one is very clear on some of the extra steps that are required to be evaluated for an assistance animal, whereas the service animal, it's like, is the animal considered a service animal? If yes, skip to question 7. So it's kind of oversteps a lot of the steps that have to be looked at for an assistance animal. So there are specific situations that a service animal has kind of different requirements versus an assistance animal.
Okay, and then I have a follow-up on that one. Do emotional support animals need to be certified or trained in some manner? Or would a note from a medical provider stating the tenant's needs this animal be enough for an accommodation?
They do not have to be specifically trained, as long as the individual is providing some sort of, or it's either a parent or they're providing some sort of documentation that the animal is necessary for them to have the full enjoyments of the property, then they do not have to have some specific training or certification or anything of the sort.
Is there anything else? All right, well, I think we will wrap it up. Thank you again for presenting. Always nice to have you. Again, for those of you that are still on, please take a few minutes and fill out the survey that will be sent out. And also, if you need a certificate of completion, please email Stacy and she will get that emailed to you. On that note, this is our last presentation for 2023. So be on the lookout come springtime for our next round of trainings. We plan to probably start them in April or so. So I hope everybody has a wonderful holiday season and we will see you in 2024.
Thanks, guys.